Mic check 1 2. Hello, welcome. This is going to be Just Human episode 358. And I have I'm about to record in this first segment some stuff about Jack Smith testifying to Congress, and also I feel like I'm really not very loud in my ears, and I think that's all on me. I think I actually turned the mic down. I'm about to record a segment. The first segment we're going to get into is going to be about Smith going into Congress to testify in a closed door hearing. I really wish it was a public hearing, and if it was a public hearing, I might go live. I'm thinking about it, if and when, which I expect there will be a public hearing at some point. I'd really like to go and cover it live. So maybe I can work that out. I haven't been live in a long time. I know a couple weeks ago I talked about how I was considering going live, and that's a hearing with Smith. That seems like a really good thing for me to cover live. I just need it to occur at a time that's going to work out with kid activities and all those things. So I'm watching for it, okay? And I'm hoping I can do that. If not, I'll find some other reason to go live. But anyway, our first segment today in this episode is going to be about Smith testifying. It's going to be a short segment because it hasn't happened yet. But I thought it'd be worth getting this out and kind of telling you guys what my thoughts are going into it. And I have a prediction about it. And we'll see if that prediction proves true. So you guys can, in the comments, you'll be able to tell me you were right or you were wrong. And that's always great, right? And then we're going to get into the case of, in this episode, we're going to get into the case of Richman v. United States, which is person 3 from the Comey indictment. He has sued the federal government for his property back. That property being the material that was seized pursuant to the 4 search warrants in the Arctic Haze investigation. And some of that information, as you probably recall, if you followed the Comey case with me, was later used against James Comey. And the government, if they're going to reindict James Comey, as many think they are, and as the government is examining doing right now, they're going to need that stuff in order to reindict him, right? So Richman is suing DOJ for that material back or for its destruction. He doesn't actually need the copies of it. He needs them to destroy it. And so his lawsuit is effectively trying to gum up the works and stop DOJ from being able to reindict his friend James Comey. At least on the surface, that's what it appears to be. But there's also a chance there's a little bit more going on, and I'm going to get into that. And I made I have right now recorded 2 segments for that, and I've released them as their own videos on my YouTube and my Rumble. And I'm just going to put those videos into this episode of the podcast, and there'll be timestamps. So if you've already watched those videos, thank you for watching them, and thank you for liking and commenting on them if you did so. If not, please do. And so I'm going to put timestamps on this episode so that if you want to, you already saw that stuff, you can skip it. Or you can listen to it again, enjoy it all over again, and maybe have some new thoughts on what's there. And then I'm not quite sure what else I'm going to fit in this episode. I have a list over here of things I want to cover. And I'm just going to tell you what they are. I want to record some videos that are, this is just ahead. This is not just in this video. This is just like over the next few weeks, what's on my mind that I want to record some videos about. I want to do a new recording on United States v. Asif Merchant, which is the Iranian assassination who came to the U.S. last year and was trying to network some people and meet with some hitmen in order to assassinate Trump, John Bolton, Mike Pompeo, and whoever else in the first Trump administration he could get. So his trial's coming up either in January or February. At least that's what it's scheduled for right now. And since I'm back on YouTube, which, by the way, if you're not following me on YouTube, I'd really appreciate you following me over there. I want to record some new videos on it and kind of like brief up a playlist on that case ahead of the trial that's going to happen early next year. And I already have videos on it on Rumble, but I don't on YouTube, and I don't really want to upload old videos. I would rather just record some new videos and like reintroduce the case. And then there's 2 cases that have to do, really there's more than 2, but there's 2 main ones. There's an a counter espionage case and a cyber hacking case called United States v. Dubrovnova, which is a Russian who was indicted, and I believe it's out of LA. And she's connected to 2 Russian hacking groups that hacked into U.S. infrastructure, and she was recently arrested and indicted. And that case is pretty interesting because it provides a lot of insight into some of that the cyber espionage that has been going on. There's also, I believe, one of the things they attacked. There was a water system, and there was something else, and then they also got into some the either Department of State or election types materials, and they got people's personal information. And it's just interesting. They're going after that thing, that stuff. And so I want to get into that case, and not sure how much I'll follow it, but it's an interesting story, at least to do 1 or 2 videos about. And then there's an even more interesting story with a different Russian agent. It's United States v. Zarubina, and she appears to have been a honeypot type operation in the U.S. who was operating in New York and in Texas, and she'd been caught before, but she was working for one of the Russian agents who was part of Russiagate, Dmitry Simes, who, if you recall, Dmitry Simes' property in Virginia was searched last year all of a sudden. And it was a property that he left the U.S. during Russiagate, or the early days of Russiagate, because he knew that the FBI was onto him. But he still has properties here in the U.S. And one of his properties was searched by the FBI last year, and the FBI took a bunch of stuff out, and then nobody ever knew about what was going on with it. And then later, this honeypot chick gets indicted. And it turns out she was working for him and for this other Russian agent. I think it's Alina Branson was her name. And she ran a network of Russian agents in the U.S. who were honeypotting people, who were trying to find people to disseminate Russian propaganda, and other things, other espionage and influence operations in the U.S. And that case is pretty it's got a lot of spy intrigue in it. So I'd like to do a series of videos on it and follow it a bit more closely. And then more immediately, and this will probably be, I'm going to do a video on this before the end of the week. I might get to it today. I'm not sure. There's new Clinton Foundation investigation documents that have been released. You may remember earlier this year, and I did a video on it. I think it was in October. We had the Clinton Foundation timeline that was released over the summer, but in October we had emails going back and forth where an FBI agent was sending emails to people in the public integrity section of the FBI and also to the U.S. Attorney's Office in D.C. and was asking about opening up an investigation into the Clinton into the Clinton campaign and the DNC for paying for the Steele dossier. And that was really interesting, those emails. And they were also really fun. Well, Grassley has released 80-something pages of a new, much more detailed timeline. And then he's re-released the timeline we got over the summer, and it appears at first glance to have fewer redactions. And there's more emails and memos. And it looks like under James Comey, who, of course, is very bad, no good, dirty cop, right? Under James Comey, there was an investigation into Uranium One as well, and the Clinton Foundation, and Hillary's use of an email server, and the Anthony Weiner laptop, and other investigations into the Clintons' activities. And it was all being looked at the same time. And there were efforts to tie it all together into, I don't know, some sort of grand conspiracy, racketeering RICO investigation. I mean, it mentions U.S. Attorney Anthony Huber. There's an email from the Arkansas office about Durham coming down and what he's going to bring and what he's looking at. Like, this is classic Clinton investigation stuff. This is awesome. So I'm going to do a video on that, and if I get it done before I publish this episode of the podcast, I'll throw it in this. If not, it'll be in the next one. So yeah, that's what's on my mind. I just spent 10 minutes introing the show. Sorry it took me so long, but there's one more thing. There's the foiled New Year's Eve bomb plot out of LA, and then also there's an individual in New Orleans. There's 4 individuals that were arrested and indicted in LA, and then 1 individual in New Orleans. And this is they don't say they're Antifa, but it's left-wing anarchy anti-government group. And they're called TILF, the Turtle Island Liberation Front, which when you see the acronym TILF, TILF, you might think the T stands for something entirely different, given the type of people involved with this. It might be, well, I'll just stop there. So anyway, I want to get into that case. I have the indictment, and I have on both of the, out of both offices, New Orleans and LA. But I haven't decided when exactly I'm going to record that. It is interesting. I don't know how much attention I'm going to pay to that case. Anyway, all right. Sorry, maybe I had too much coffee before I started recording. There's a lot happening. And the Richman thing was the oldest of the things on my list that I wanted to get to. So I decided to start with that first. If you're interested in following these things, the Richman case, the Merchant case, Dubernova, Zarubina, the Clinton Foundation docs, and Uranium One, and all that other stuff, New D class. If you like New D class, this is the place to get your digest of it, and all the other cases that I follow, and all the other documents that I read. If you would like to support what I do or consume it, my link tree is in the description of the show. It's also in my profile, wherever you're watching, listening, or following me. And on my link tree, you can find all the places to follow me, all the places to watch my content, all the places to listen to my content, and all the ways to support it. It is Christmas time. You don't have very many days left. But if you haven't got gifts for people that you care about yet, and you're so inclined, if you use my affiliate links for Benson Honey Farms, Bootleg Products, or Manly Cans, you can get a gift for someone. And you can also at the same time support the show. They'll kick a few dollars my way out of the purchase that you make there. I will tell you that I have used products from all of these places, all 3 of them, and I like all of their products. Benson Honey Farms has some of the best honey I've ever had in my life. They also have some of the best soap that I've ever had in my life. I know that you may not expect soap to come from a honey company, but man, it does. Goat milk soap. It's all natural, and it's wonderful. Bootleg Products has delicious chili salsa and seasonings. I use it. I cook with it. My family loves it. Manly Cans, I've gotten cans from there. I got like an assortment can. It's sitting right over here. It's full of beard products, and the products in it are great. Now, for one, there's lots of gift basket companies out there, like that type of merch you can buy for a man or a woman, right? And usually it's not very high quality. Manly Can stuff is actually of a good quality. And I find that the contents of their cans or whatever you want to buy from there is typically higher grade, much better product than what you would find in a lot of other companies that do a similar thing, right? You can also customize your cans there. They have different themes for them that you can select from, but you can also customize them. You can add things to them. You can take things away. So you're looking for a gift, especially for a manly man. It's a great place to go. Okay. On my Substack is where I put all of my articles and my podcast. And if you want to support the show, you want to become a monthly supporter, a monthly subscription over here to justhuman.substack.com, $7 a month. You're buying me 1 cup of coffee a month, and you're throwing $2 into the Pacer Fund. Okay. And if you're not subscribed to my YouTube and want to watch me on YouTube, hey, subscribe, like, and comment over there. I found that, or my information is that the sooner you comment on a video from someone you like on there, the better chance that video has to gain more views. If you put out a video and no one comments on it for the first hour, then the video dies. It's not the same on Rumble. But on X, I have also learned, which this is going to get us to our first story. On X, the way X is working now is that X basically, and this is good information for all of you who are on X. X judges whatever you post in like the first 30 seconds to a minute. And if in the first 30 seconds to a minute after you post, it doesn't get engagement, it basically gets slotted into a low quality tier and it dies on X, basically. If you post and it immediately gets some sort of engagement, then it goes up into a higher quality tier, and X will push it to your followers. And so like when you wonder why you haven't seen posts from someone you follow on X and for so long, and you wonder why your following feed doesn't have recent posts from people you follow, it's typically because whatever they posted didn't get a comment or engagement immediately after they posted it. That's what X is now geared towards looking for. I don't agree with it. I don't like that system, but that's what it is. The other thing that X is doing is content that uses language that is divisive, polarizing, sensational, full of hyperbole. X puts that in higher quality tier, regardless of what it actually is. And in content that is breaking things down, giving nuanced takes, giving bare information that doesn't have a lot of loaded language in it, X automatically puts that in a lower tier. So for someone like me, who preaches understanding is greater than reacting, puts me at a serious disadvantage. And people who lead with reactions at an advantage. That sucks. So that's FYI for your interactions on X. And yeah, I'll just leave it at that. Okay, I'm going to change how I'm sitting. I like, whatever reason, I like sitting cross-legged whenever I record. I'm most often sitting cross-legged in this chair. It just, I don't know. I don't know why I'm commenting that to you either. Okay, hopefully my cord doesn't come unplug again like it did twice during recording yesterday. All right, you ready? Y'all ready for this first segment? All right, folks, you may have noticed that yesterday there was a story going around from Brooke Singman over at Fox News, who's pretty good. She tends to have, and by pretty good, I mean she tends to have some leads and some exclusive stories in areas of my interest anyway. And so she's someone I have notifications turned on for, because she's, over the past year, she's regularly dropped some really dasting information, right? Well, yesterday she kind of, I'm not insulting her, but she kind of sullied that reputation. She kind of downranked for me a bit, because yesterday she ran this story exclusive. The FBI did not believe it had probable cause to raid Donald Trump's Mar-a-Lago home in 2022, but they moved forward anyway amid pressure from Biden DOJ and officials saying he didn't give a damn about the optics of the search. That jerk said that. So she ran this story, and when I saw it, I was like, oh, there's new information about the Mar-a-Lago raid search. Okay. All right. And of course, one of my most popular stories I've ever written right here is templates from August 24th of 2022, is about the Mar-a-Lago raid search, and it's where I proposed my theory, which I feel I've been proven, maybe not proven right, but I think I've been largely right, that a lot of the actions that Trump has engaged in and that has been Trump has been put up to, or people around him have gone through, are to set legal templates for future prosecutions. Well, that's my whole thing. And anyway, that article is all about that if you've never read it. So I was really intrigued, like, what new information is there about the Mar-a-Lago raid? And so I went to this article and I started reading it. All right, the FBI didn't believe it had probable cause, and one official said he didn't give a damn. And Fox News Digital reviewed emails between FBI and Justice Department officials in the months leading up to August 2022. And the FBI officials expressed concerns about the lack of probable cause to execute a search warrant. And I kind of thought, well, I remember this coming up in United States v. Trump, which are both cases that Jack Smith brought. And I covered basically every filing in both cases for you guys, and was really just like a pit bull with that case. And so I was like, all right, well, maybe there's some new stuff here at this link. Nope. It's an article going all the way back to August of 2022. So that's not new. All right, well, there's not new stuff there. So I kept reading. And let's see. Very little has been developed. Washington field office has been drafting a search warrant affidavit. And I'm looking at this and I'm like, where's the new information? I didn't see another email said this and another email said that. I'm looking at this. I'm like, we've gotten some of the emails from the Mar-a-Lago raid. And I remember reading emails that said all these things like 2 years ago. And I got to the bottom and then it regurgitates some information here. And then that's it. There's no new information in this article. There's nothing new in it. And it says exclusive. So I went and checked it again. And right now you're watching me look at it for the 4th time. And so like, okay, well, maybe this is something new. So let's click on this. Nope. August 2022. All right. Are there any other blue links to click? Okay. Nope. August 2022. Okay. What about this one? Well, this is from May of 2024. And this says Trump highlights Biden admin authorizing deadly use of force in Mar-a-Lago raid. Everybody get mad. Everybody be appalled at that. Even though the FBI is always they're always authorized to use deadly force. It's a standard protocol. They're law enforcement. When law enforcement goes a place, they're authorized to use deadly force in the same way they're authorized to use deadly force at any other time. And they're also authorized to use non-deadly force. This is one of those clickbait fake news stories, and this is not the first time I've talked about this specific one. This story about the Biden admin authorizing agents to use deadly force as they raided Trump's Mar-a-Lago. They were suited up in military gear, blah, blah, blah. It's just sensationalism. It's just WWE over the top narrative warfare junk. It's outrage bait meant to get you upset and meant to push a certain narrative. And we should all be too smart for it. You know, that's just, I'm just going to take this short little rabbit trail. That's one of the things about fake news and the sensationalism and the overreactions we see in media and from clickbait outlets, from influencers, from outrage baiters. The thing that gets me upset about that stuff, it like grinds my gears, is that it insults your intelligence. That's how it hits me. My intelligence is insulted. I'm offended when this kind of thing gets pushed to me and when people repeat it to me and they're trying to get an emotional reaction to me and they're trying to get me to buy their narrative about things based on emotional reaction. That's insulting. And I wish more people would be insulted by it, because people would then turn away from it and it wouldn't be as pervasive or as monetarily rewarding. But unfortunately, we're humans. Or fortunately, we're humans. But one difficulty in being a human is that type of psychological operation, getting someone emotionally connected to a piece of information so that you can then manipulate them, is highly effective. Highly effective. And that's why it's done over and over again by Fox News, by CNN, by the biggest accounts on social media, by politicians. And that leads me to the next part of this. So there's nothing new here. This is a 2-year-old plus 2.5-year-old story. And this was also something that was dealt with by Judge Cannon. And so I saw this and I just, for fun, I posted this GIF, what's a rerun? Because I'm saying, like, this is a rerun. That's what this is a rerun. Why are they rerunning this? Why is Brooke Singman, who, again, she's been a good source of some breaking info recently, as in over the past year. Why is she participating in this sort of, to me, this is clickbait. It's regurgitated clickbait. There's a few accounts I could name right now who do that kind of thing all the time. They regurgitate old news from the past like year or more, usually from news from in the past 3 to 6 months, but they won't link to any sources. They'll just restate news from 3 to 6 months ago with sensational language, and they'll go viral with it because people have short memories and people emotionally react to what they're saying, and they just share it around without any circumspection or discernment. So I wonder, like, why is this going around? Well, this is why. It's because today, 24 hours after she did that, Jack Smith is at Congress. He's on Capitol Hill. And he's going to be testifying in a closed door hearing. And I agree with this headline. Jack Smith wants to tell Congress about his Trump investigations. He said so in a letter back in October, which I'm going to talk about in a minute. The thing is, though, that's what he wants to do, but it's going to be in a closed door session. And it's a setup that favors politicians, because what politicians want to do is they want to score political points, and they want to, both sides want to shore up and reinforce their own narratives about Smith's investigations. Republicans want to score political points and say it was all crooked and deep state and Jack Smith is a liar and he needs to be indicted and all that kind of stuff. And people on the left want to say Trump is a criminal, he's a felon, and I don't even think so much they want to praise Smith as they want to just reinforce those notions about Trump. And so Republicans are going to be attacking Smith and Democrats are going to be attacking Trump. And that's what you're going to get out of this hearing, although it's going to be closed door. So that provides, they're still going to do that even though it's closed door. But because it's closed door and because Smith is going to be restricted in what he can say, he's going to be limited in what he can say to lawmakers, which I'm going to explain why in a minute. Because that's going to be the case, and because it's going to be behind closed doors, that particular setup favors the politicians on both sides. Because both sides, but especially I think Republicans will take advantage of this, they'll be able to say later today that Jack Smith refused to answer my questions, blah, blah, blah. So that's my prediction that I want you guys to watch for. Let me know in the comments if you saw any politicians doing it, regardless of what party they belong to. And let me know if you see them saying things along the lines of, I tried asking about this, but Jack Smith refused to answer. Or we had some very serious questions, but Smith wouldn't answer them. Anything like that. Because that it's going to be so easy for them to say things like that because they know damn well that Jack Smith can't answer all of their questions. And we see this over and over again. Matt Gaetz was one of the worst ones who used to do this all the time in Congress. Thank God he's gone. Although he's not completely gone from all of the media and political sphere yet. But many politicians do this on both sides. They play that game because they, again, They're insulting your intelligence as the viewer and as the voter. They know that most people aren't going to be aware of what limitations are on whoever it is they're asking questions or talking to. And they'll use that to their advantage to reinforce their own, to try and score political hit points and to shore up their own narratives. The limitations on Jack Smith are that he can't disclose information from sealed grand jury materials and proceedings, which the grand juries that were used to indict Trump in DC and in Florida, their materials and their proceedings are sealed. He can't talk about that stuff. Doesn't mean they can't ask about it, though. And it doesn't mean that when they ask about it, they can't then later go on media or on social, on any kind of media, televised or otherwise, and then complain about how Jack Smith wouldn't explain to them about what he did in the grand jury. He can't disclose information that DOJ restricts prosecutors from discussing, which is just universal. Prosecutors can't discuss all the aspects of their investigations and prosecutions. It's secret. There's all sorts of things that keep it secret. If it's already been disclosed, if it's already been declassified or come out in a FOIA lawsuit, he can talk about it then. If it came out in court filings, he can talk about it. He can talk about that. But stuff that hasn't been disclosed, he can't talk about. He also can't disclose information from his final report on the classified documents case in Florida. That report is currently sealed by Judge Cannon, and Trump wants it that way. Trump endorses the secrecy on that classified documents report. Now, this is pretty unique because what's going to happen here is that they can ask questions about it. He can't answer them. And then Republicans will push whatever narrative they want to about that. Jack Smith bad, won't answer our questions. Democrats can do the opposite and say Trump bad. He wants this report secret because he knows it makes him look bad. Blah, 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 blah. You see the game? The damn game. Now, as I've talked about before, I don't remember if I put this in a video or not, but back in October, Smith stated in a letter to Congress that he wished to speak with Congress and answer questions in a public hearing. And he asked for DOJ to restore his access to, one, his special counsel files, to give him guidance on answering Congress's questions, which means I think that goes back to this limited restriction here about disclosing information from the investigation. He's wanting DOJ to tell him, look, you can talk about this in your investigation. He wants guidance from DOJ on what he can do in answering these questions. And then he also said he wanted assurances that he won't be punished, quote unquote, for answering Congress's questions. I'm not sure what DOJ granted him, but we now know, thanks to this Politico article, that DOJ did provide an authorization letter to facilitate Smith's testimony according to a person granted anonymity to share details. But the scope of the waiver is not clear. So he got something, which is great, but we don't know exactly what the scope of it is. So I would really like Smith to have a public hearing, and I would like to cover it for you guys live if I can make arrangements to do that. And yeah, I would like it. And also Trump wants it. Now, last thing I said, this is something I wrote about a week and a half ago, after Trump made some comments about wanting Smith to testify. And so here are just my thoughts that I had a week and a half ago about Smith coming on the Hill. And I said, I think if and when Smith testifies before Congress, it'll be extraordinarily interesting for discerning viewers, which there's going to be a few of us. I would love there to be a lot, but I think there's only going to be a few because of the nature of these things. I don't believe, though, that Jack Smith is going to come across as rabidly anti-Trump as he's portrayed to be. And at the same time, it will be deeply frustrating for those same viewers because the hearing will be intensely partisan, just as it was with John Durham, which I did cover live back when I was on Badlands Media. And there are parts of that that were great, but it was also extremely frustrating because it was just political games with the Democrats trying to attack Durham and also the Republicans attacking Durham. And then some Democrats trying to defend, or no, I remember it this way. There was a portion of Democrats who were attacking Durham and a portion of Democrats who were just attacking Trump. And were basically, it didn't matter that John Durham was there. And then there was a portion of Republicans who were trying to get some information from John Durham and asking him decent questions. But it seems like about half or more were just focused on bashing Durham. And it was just so frustrating because it was just a clown show, right? Too many clowns in the room. And with Smith, I think it'll be the same thing. Both Republicans and Democrats will be eager to evoke and land their preferred sound bites, fully focused on advancing their chosen narratives. They'll try to box Smith in, forcing him to phrase or acknowledge pieces of information from his investigation in ways that serve their political ends, regardless of what the facts actually show, what the investigators actually found, or what the truth actually is. The hearing will also be extraordinarily uncomfortable for members of Congress. Many of them will not want Smith to publicly detail the predicates and probable cause he relied on when obtaining search warrants for their communications during Arctic frost. That will also be key to Smith's testimony. They want to make him look like a bad guy because remember, Smith got access to Republicans' toll records and who they called and when and who they texted and when they texted them as part of his DC indictment against Trump. And they are very mad about that because they don't want DOJ ever looking at their communications because, well, swamp's got to protect the swamp, right? And they pretend like Smith didn't have any predicate or any probable cause to get such information when the courts disagreed. The court said he did. He got court authorized search warrants. That's also why he'll be I doubt he'll be testifying anytime soon, at least publicly. I hope he does, but I would not be shocked if there's a drawn out process to make this happen. And I wouldn't be surprised if Congress drops it after a while because there's a risk to them as well if it's a public setting. Both parties, but especially the GOP, are now heavily invested in a newly constructed narrative that the big bad FBI DOJ must be reined in and restricted from investigating members of Congress, and that's why they've made such a big deal of Arctic frost. On the surface, these proposed restrictions, namely the notifications to reps and senators, are framed as protecting against DOJ overreach and safeguarding constitutional rights. But in reality, their primary purpose is to protect the swamp. Nobody wants to be the next gold bar Bob Menendez and end up in federal prison. Bob got caught again last year or the year before, and that spooked these guys. Don't underestimate, regardless of political party, don't underestimate how spooked the senators and the congressmen, representatives, don't underestimate how spooked they are that the former chairman of Foreign Relations Committee, of several other committees, Senator Bob Menendez, who had survived a previous investigation and indictment and then was being enriched by the Egyptians and the Qataris, I believe, if I remember right. Yeah, don't be surprised at how spooked they are. Don't underestimate it. They are very spooked because he was pretty close to untouchable, especially since he'd already survived one. And they remember Rep. Quellar is another example. He got busted because he was linked up with mobsters in Azerbaijan and cartels in Mexico. And Trump just pardoned him, or they dropped the investigation, whatever it was. I forget which. But I think Trump pardoned him or had them end it. But I think Trump saved his life, possibly. I think this guy was in danger because of his links to the cartel. I'm not saying that he didn't do anything wrong. I think he did. It seems so anyway. But I think he got a pathway out of trouble and out of danger. So Congress is very bothered. And that's why they're trying to make some sort of special exception for themselves. They're framing it as protecting against DOJ overreach and safeguarding constitutional rights. No. They're trying to make a special cutout for themselves and get themselves special protection that nobody else would have. In Smith's letter, he's volunteering to testify. This one right here. He's volunteering to testify. He has requested access to his office's files and all that other stuff that I already mentioned, and clearance to talk about things. Congress wants Smith in a hearing so they can berate him and get viral clips for their social media. Smith wants to be in a hearing so that he can defend his investigations and detail what he found and the steps he took to get it. Trump wants Smith in a hearing for the spectacle and so that he can further clear his name. These are my opinions. These are the different groups. You got Congress is the same regardless of party. They want to score political points. And one side wants to berate Trump. I should have included that. And the other side wants to berate Smith. But Smith very much wants to defend his investigation. And Trump, he knows that if Smith goes in that hearing, the likelihood is that it's going to help him clear his name. And he also likes the spectacle. Trump may also want, and I think this is a potential here, don't miss this. Trump may also want Smith to serve up an opportunity for him to go on Truth Social and ridicule Corcoran, Cheesebro, Eastman, or any other one of the swampy people who were trying to frame Trump. Now, I know there's lots of disagreement with me on that, but I'm firm on that. I think those three guys plus others were trying to frame Trump. Corcoran in the Docs case, and then Cheesebro and Eastman in the DC case. I think they tried to frame Trump leading up to January 6, 2021. They were trying to trick him into endorsing and pushing the false elector scheme, and he didn't fall for that trap. And then they got trapped. And Corcoran was trying to set Trump up in the Docs case. So that's my take on it. Let me know what you guys think about this. Any of the stuff I just covered in this video. Let me know your thoughts on it in the comments, and I'll see you in the next video. Hey, what's up, folks? I'm back with another video focusing on a court case that isn't United States v. Comey, but relates to United States v. Comey. It's the case of Richman v. United States. Richman is Daniel Richman, who was person 3 in the indictment against James Comey that just ended thanks to the dismissal by the judge, ruling that Lindsay Halligan was unlawfully appointed to be the interim attorney for Eastern District of Virginia. And now that that case is gone and very unlikely to be revived, I know there's a lot of accounts that are saying it's coming back. It was dismissed without prejudice. Don't you notice that, Kyle? Don't you notice that, Just Human? It's dismissed without prejudice. That means it can be refiled. Don't expect it, guys. Don't expect it. But this case, Richman versus United States, is the professor Daniel Richman suing the government for his property back. The property that the government seized pursuant to 4 search warrants during the Arctic Haze investigation. And the material that was seized then formed the crux of the evidence that was used against Comey to get the indictment, and evidence that was used improperly, that was referenced improperly. by the one witness, the FBI agent who testified to the grand jury and was also referenced by Lindsay Halligan. So even if Lindsay Halligan was lawfully appointed, I still believe that the case would have been thrown out for Fourth, Fifth, and Sixth Amendment violations. So this Richman case, though, you've probably heard about it because you've probably heard it described as the government is making sure that, or the court, some crooked judge is making sure that this evidence can never be used to indict Comey, blah, blah, blah. They're going to make sure the case never had whatever clickbait, outrage bait is out there. There's so many flavors of it every day, all day. But what I want to do is I want to focus on this case and track it because there's been some developments with it. I'm a little bit behind on it, admittedly. There's been a lot of news that I've wanted to cover, and this is a news item that I've set aside for now. But I think it's very important because I think that the evidence that we're talking about, it's not just the couple lines of communication that involved Comey talking to Professor Richman. There's more than that. There's all of Richman's iCloud account, a computer hard drive, searches of his email, searches of his iPad and iPhone. And Richman wasn't just involved with conveying information to media on behalf of Comey or on his own, which he did on his own a number of times as well. He was also communicating with others. And there's some... there's a chance that's within this information, within the materials that they got with these search warrants that went beyond their scope. There's evidence or materials that relate to some other case. And I think that's a little bit of what's going on here, is that there's evidence that relates to some other case. And I said at the beginning of United States v. Comey, I have said since it first dropped, this isn't about getting Comey. This is about getting at some materials that are currently sealed. And the materials that were sealed are this. It's this stuff that was seized pursuant to those 4 search warrants that up until the Comey case had been sealed for 4 years. And thanks to the Comey case and the orders from Fitzgerald, the magistrate judge who was taking a look at this material in the filter team, these search warrants were ordered unsealed. And now we've got a little bit of an understanding of what the search warrants were for and an understanding that the FBI went beyond the scope of those search warrants in gathering materials from Richman. Were they directed to do that? Did they go beyond it because they were told to by a certain deputy director? Because he wanted to protect himself against the comeuppance that he deserved? The reckoning that Comey had arranged for him to encounter down the road? Perhaps. I think there's a little bit more going on here, and that's why I'm going to take the time to go through this case, filing by filing with you. I hope it's one that you find interesting, and I hope you will join me for it. Now, if you want to support, that is the wrong button. If you want to support me hitting the wrong button every now and then, what you need to do is go to my link tree, and there you can find all the places to follow me, all the places to watch, all the places to listen, and all the ways to support her down here. I got some affiliate links, Benson Honey Farms, bootleg products, and Manly Cans. If you're looking for a Christmas gift for someone, those are excellent places to go. They're all places that I have gotten products from and that I genuinely enjoy their products. But there's also, if you just want to buy me a cup of coffee, Ko-Fi.com, or if you want to be one of my core supporting members, justhuman.substack.com is where I put out my articles and where I put out my podcast, my long form podcast, which this will probably get put into. And a paid subscription there. Everything on there is free. You don't have to be paid. But if you get a paid subscription there, it's $7 a month. And that's basically $5 to my coffee fund. You buy me 1 cup of coffee a week or a month, and you're contributing a couple bucks to my Pacer habit. So I have some videos on, I have playlists for all of the cases that I cover on YouTube and on my Rumble page. And this one is going to be added there, Richman v. United States. So this is going to be the first video that I'm going to make in this case. Forgive my voice. It's not as clear as I would like it to be. For whatever reason. I don't know what's going on. My voice doesn't feel the same today. Okay. So this started November 26th. So days after the Comey case was dismissed. I'm going to kill that one. I got so much news to cover, man. I got so much news to cover. And this is one I set aside. So I have a list here of all the things I need to get to. And this was like the oldest one that I wanted to get to. And I was like, well, I don't know where to start with this list of news that I want to cover in videos for my audience, but I'm just going to start at the oldest one. That makes sense. I'm going to gotta start somewhere. And it's only going to get older if I don't get to it now. So this is the case, Daniel Richman versus United States. It's in D.C. instead of the Eastern District of Virginia. It's in the District of Columbia. And I believe that's because the search warrants were out of D.C. and because, well, it's probably because he's literally suing the federal government, DOJ. But also the original 4 search warrants were out of this district. And that's the material that this is at issue, that he's wanting for it back. So pursuant to Criminal Rules of Procedure 41G, Professor Richman moves this court to give me my stuff back. It's going to be called the materials. And the materials at issue, you guys need to turn, you've had it for years, and I want it back. I don't know if he's ever tried to get it back before. It's almost like things are kicking off sequentially, like there's some sort of, I don't know, plan. Anyway, so here's his memo. I don't get too carried away with that. I do think there are plans, but I'm not super everything is a plan, 10D strategy. You're watching a movie. I used to be a little bit more that way. I'm not near as much that way now. But I'm not fully off that either, especially when it comes to stuff like this. So this motion seeks redress for the government's violations of petitioner Daniel Richman's Fourth Amendment rights. Between 2017 and 2020, Professor Richman, an attorney and law professor with a distinguished record, had various interactions with the government relating to its legal representation, or his legal representation, of FBI Director James Comey and Mr. Comey's handling of potentially classified information and related communications with the media. Professor Richman agreed to allow the government to image his personal computer for the purpose of identifying and deleting certain sensitive documents, and subsequently agreed to a limited search of the image. This doesn't say that a search warrant was executed and that's why they imaged his personal computer, does it? Notice that? It says that Professor Richman agreed to allow the government to image his personal computer for the purpose of identifying and deleting certain sensitive documents, and subsequently agreed to a limited search. Why did he agree to let that happen? Well, that goes back to the Comey memos. Memos that would become a bit controversial and that the media was very interested in getting because they viewed them as Comey's secret notes about his meetings with Trump, and it would allow them to attack Trump. And, you know, the whole loyalty thing, that he asked Comey for loyalty and then he fired him because Comey wouldn't give it to him. And that kind of began the media's turnaround on Comey, where they had hated him because they believed he sank Hillary Clinton's presidency, and that's what Hillary Clinton believes. And so they had all, the media, mainstream media, was just after Comey, after the election loss of Hillary. And then because of Comey making these secret notes, that completely changed the media's treatment of Comey, because they viewed him as a guy who could turn on Trump and give them all this dirt on him. And so these memos that Comey wrote, which he would have a meeting with Trump and then he would write down either immediately afterward or the next day, he would write down some notes about his conversations with the president. Those became something the media really wanted. And Comey, after he was fired, he would send some of these memos, and today we have copies of them. They're these right here, and I've gone through them on an episode before, and they're not nearly as scandalous as what the media hoped they would be. In fact, they actually, I think, cast Trump in a good light. When you read the full thing, I think they actually cast Trump in a very good light. And Comey as well. But no media organization is, if they want to make a lot of money, they're neither one is going to have such a tame view of it. They're going to portray it in the most scandalized and sensational way as possible. But anyway, these memos were not classified. And Comey took them, and he was careful not to put classified information in them. But then after he was fired, and he had handed them off to Richman and to Patrick Fitzgerald and one other person whose name escapes me right now. The guy hasn't really come up. Is it Kelly? I want to say, is it Kelly? I think his name's Kelly. Anyway, after that had happened, when Deputy Director, now Acting Director, Andy McCabe found out about this, he was freaking spooked because he was worried about what Comey had hidden about him, because he knew that he was in deep trouble. McCabe knew after Comey had been fired, McCabe was probably really happy about it at first. But it wasn't that long until investigators from the inspection division paid McCabe a visit and asked him about certain leaks to the Wall Street Journal that previous October, which McCabe was responsible for and pretended to not knowing of anything about, which we've gone over this before and I have a whole video on it. So McCabe scrambled to try and find out what was in Comey's memos and who he had given them to, and this resulted in an up classification of the memos. And that's how Richman loops in here. And that's what this line is about, that Richman agreed to allow the government to image his personal computer because the FBI went to go visit Richman and find out, hey, what do you have? What did Comey give you? And what he had was memo number 4. And I think he may have had some others. It's in here in this report, who had what and all that, but it wasn't classified. What happened was later on, they up-classified one word of one memo, and the media, especially media on the right, now makes it seem like Comey sent all this classified information to Richman when that wasn't the case. So, but I think the purpose of it, from McCabe's view, wasn't so much his worry that classified information was out. He was worried about what information Comey had distributed about McCabe's crimes, particularly having to do with the Clinton Foundation investigation, mid-year exam, maybe Uranium One, those things. And I think right here in Horowitz's report, there's something very interesting, and I think that this is what might be in the messages that was used by Lindsay Halligan to indict Comey. I think these are the messages that were described to the grand jury to indict Comey, even though it's factually erroneous. So the allegation, remember, in United States v. Comey was that Comey, while FBI director, had instructed an FBI employee to convey classified information to the media. That's not true as far as we know. There's no evidence of it. It doesn't matter. Influencers and right-wing media constantly say there is. But they're counting on their audience being ignorant of what actual evidence we have of that happening. It's mostly just inference and assumption. Right here it says, however, after his removal as FBI director 2 months later, Comey provided a copy of Memo 4, which Comey had kept without authorization, to Richman with instructions to share the contents with a reporter from the New York Times. Memo 4 included information that was related to both the FBI's ongoing investigation of Flynn and, by Comey's own account, information he believed and alleged constituted evidence of an attempt to obstruct the ongoing Flynn investigation. Later that same day, the New York Times published an article about Memo 4 titled "Comey Memo Says Trump Asked Him to End Flynn Investigation." The responsibility to protect sensitive law enforcement information falls in large part to employees of the FBI, and this is where Horowitz found fault with Comey and said former Director Comey failed to live up to this responsibility. But it wasn't a crime. It was a violation of FBI regulations, standards, or whatever. And ultimately, he wasn't charged with anything. And what they're talking about is this memo number 4, which simply says, let's see. Talking about the Steele dossier and that one. You've heard the line before, but I want to find it and show it to you in here. I do think there's some stuff in these memos that we haven't fully realized what their impact is. I don't think these memos are done yet, being a subject of conversation. I scrolled past it on accident. Professional would pause the recording. There it is. Okay. President sent Reince Priebus away. And then he returned to the topic of Mike Flynn. All right, let me find where he first mentions Mike Flynn. All right. The president joined the brief exchange, but then told Mr. Kushner he wanted to meet with me. That left the two of us alone, Comey and Trump. He began by saying he wanted to talk about Mike Flynn. That's quote, talk about Mike Flynn, in quotes. He then said that although Flynn, quote, hadn't done anything wrong, end quote, in his call with the Russians, a point he made at least 2 more times in the conversation, he had to let him go because he misled the vice president, whom he described as a good guy, quote unquote. He explained that he just couldn't have Flynn misleading the vice president, and in any event, he had other concerns about Flynn and had a great guy coming in, so he had to let Flynn go. He asked me if I had seen Sean Spicer's brief that day, and then that was it, okay? And then he referred at length to leaks related to Mike Flynn's call with the Russians, which he stressed was not wrong in any way. He had made lots of calls, quote unquote, but that the leaks were terrible. I tried to interject several times to agree with him about the leaks being terrible, but was unsuccessful. When he finished, I said I agreed very much that it was terrible that his calls with foreign leaders were leaked. I said they were classified and he needed to be able to speak to foreign leaders in confidence. Note, because this is an unclassified document, I will be limited in how I describe what I said next. I then explained why leaks purporting to be about FBI intelligence operations were also terrible and a serious violation of the law. I explained that FBI gathers intelligence in part to equip the president, et cetera, et cetera, et cetera. Reince Priebus popped in, and then he told him to leave. And then Trump returned to the topic of Mike Flynn, saying that Flynn is a good guy and has been through a lot. He misled the vice president, but he didn't do anything wrong in the call. Trump said, quote, I hope you can see your way clear to letting this go, to letting Flynn go. He is a good guy. I hope you can let this go, end quote. I replied by saying, I agree he is a good guy, but said no more. The president then wrapped it up, and that was it. No more mentions of Flynn. The media made a huge deal about this, and that's what is being referenced here about that article where it says Comey memo says Trump asked him to end Flynn investigation. Okay, anyway. So that's what all led. That's why Richman, there's a point at which Richman agrees to let the government look at his computer because they're looking for that memo because McCabe sent them to go collect copies of it. Let me see if it says image computer in this. Let's see. There we go. The FBI took steps, although not until several months later, to delete the memos from Fitzgerald and Kelly's computer accounts. In response to an October 31st, 2017 request from the FBI, Fitzgerald voluntarily and promptly provided the FBI with addresses and identifying information for all the email accounts belonging to him, Richman, and Kelly. Kelly's the third. So all 3 of these guys were counsel to Comey at that time. to which copies of memos 2, 4, 6, and 7 have been sent. November 20th, 2017, January 16th, 2018, FBI agents met with individuals and IT professionals associated with these accounts and confirmed that the emails and copies of the memos were deleted from the computer systems that had received them. Let me see. Right here. June 13th, 2017, FBI agents, so this is a month after Comey's fired, went to Richman's home in New York to remove his desktop computer. On June 22nd, 9 days later, FBI agents returned the desktop computer to Richman at his home in New York after taking steps to permanently remove the memos from it. While at Richman's residence on that date, the FBI agents also assisted Richman in deleting the text message with the photograph of the memo from his cell phone. So this is where that comes in. I know I've just gone off on this tangent for like 10 minutes about this one sentence, but it's important to have this distinction here that Richman voluntarily allowed the government to image his computer. Because I think Richman had more than the memos. Well, I don't think that conclusively. I think there's the potential that Richman had more. I'm not saying he had anything classified. I'm not saying he did anything wrong. I'm saying there might have been some other stuff there. It might be useful in investigations happening now. Okay. The government later obtained warrants, 4 warrants, that authorized additional searches of the image that they had of the computer and of Professor Richman's email and iCloud accounts. Professor Richman was never charged with a crime and had no contact with the government regarding these matters between 2021 and 2025. On September 25th, 2025, Mr. Comey was indicted. We all know this. And that the case was then dismissed, and disclosures in the case brought to light troubling facts concerning the government's handling of the materials it obtained from Professor Richman between 2017 and 2020. First, the government violated the warrants that authorized its searches of Professor Richman's files by apparently failing to identify and segregate responsive materials, thus seizing the entirety of the search materials. Second, despite having no need for those materials after 2021, when its investigation closed, the government nonetheless retained the materials that it collected from Professor Richman's personal computer, email, and iCloud account. Finally, and perhaps most egregiously, in a last-ditch effort to support its prosecution of Mr. Comey, the government conducted new warrantless searches of Richman's files, which is another reason why this Comey case would have been dismissed anyway. And they also violated Comey's Fourth Amendment rights and his Sixth Amendment rights because these files were covered by attorney-client privilege, which is another reason why the Comey case was going to be dismissed. There was a ton of fail-safes or inherent flaws with the Comey case. It was fatally flawed, as I told you guys the entire time. The government's conduct has deprived Mr. Richman, or Professor Richman, of his constitutional rights and injured him, blah, blah, blah. Then background, 2017 to 2018, Professor Richman consents to the image. The story begins in 2017 after the New York Times published that article, and then they went looking for that. I just covered all of this with you guys. During his testimony, Mr. Comey stated that he had shared at least one of the memoranda with Professor Richman. They were later up-classified, as it says here, these memos. They were not classified at the time Comey did it. McCabe up-classified them because he was very nervous. Then there's this redacted portion here, which is intriguing. I don't know why it's redacted. And I don't pick up on a context clue as to why it's redacted. But it just starts, next section is the Arctic Haze, which Arctic Haze had to do with a different article. Separate from the FBI and OIG outreach to Professor Richman in 2017 and 2018. So separate from that, Arctic Haze gets spun up. And that had to do with the Comey article that contains information about the Renteria memo for the first time. And that's when the New York Times had classified information. And the FBI was trying to figure out how the heck the New York Times had classified information, which was an investigation that was started under Comey. You know, kind of like one of the things that should kind of be this big, like, bleeping klaxon to people when certain orgs try and talk to you about how media orgs and influencers trying to talk to you about how, Comey leaked all this stuff to the media and everything and all this. Well, so many, not all of them, but several of these media leak investigations, they had their origin while Comey was still FBI director. One of them is Tropic Vortex, which ends up being like the main one that Durham takes over with the United States Postal Inspection Service, and he's looking for who is the leaker in the FBI. Of course, we know now that it was McCabe and Lisa Page, but there might be more. You would think that there are more than that. But there were several of them that were spun up right as Comey was fired, which means they had their earliest beginnings before this opening EC was pulled out and they went full investigation. There was a preliminary investigative phase, and that would have happened before 12th of May, 2017, 10th of May, 2017. This one is much later, and this is after Director Wray takes over, which, of course, we're all supposed to believe now, depending on what media source you follow, that FBI Director Wray is a very bad, no good guy, just like every other FBI director that media on the right tell you about. They're all bad, according to media on the right and influencers on the right. Topic for another day. So Arctic Haze gets spun up. They get these 4 search warrants on Richman because they're trying to figure out, did he leak this classified information to the New York Times? Because they know he had a relationship with them. But if you remember what the crimes they were looking for were, it was removal of national defense information or removal of government records and distribution or transmission of national defense information. August 27, 2019, the FBI obtained a warrant authorizing the search of the hard drive that contained the forensic image of Richman's personal computer. That's warrant number 1. And then there's an attachment to it. On October 22nd, 2019, the FBI obtained a warrant authorizing the search of 2 Columbia University email accounts that belonged to Professor Richman. So they looked at his hard drive. Now they're looking at his email accounts. And then next, January 31st, 2020, they go to look at Richman's Apple iCloud. And then there's an attachment on that one, which we'll read about in a second. And on June 4th, 2020, 6 months after that, FBI obtained a warrant authorizing a second search of Richman's hard drive. And it also had an attachment. Now, right here, it gives us the attachments. They're Exhibit B, C, and D to this motion. But unfortunately, we don't have them. They're sealed. Right there, it lists them right here. There's more, too. Sealed motion by Richman. And I find it interesting because these search warrants are supposed to be unsealed. And I'm not going to make too big of a deal of this, but we know there was an order from Magistrate Judge Fitzgerald to unseal these search warrants that are now 5 years old or older. The most recent one is 5 years old. The other ones are like 6 and 7 years old. Why? And the investigation was closed in 2021. So why are these still sealed? One, why are they still sealed 5 years after the investigation ended? But 2, why are they still sealed after another judge ordered them to be unsealed in United States v. Comey? And I just wonder if there's some other thing going on that is continuing to enforce this sealing of these search warrants. Let's just put a pin in that as a possibility. And then right here, we have redactions that have to do with that other warrant. To go back and look at the hard drive again. And really, I don't think Professor Richman, I'm not alleging anything about Richman, to be clear. I'm not alleging that Richman did anything wrong. But that doesn't mean he doesn't contain materials or information that is relevant to some investigation into someone else's wrongdoing. I find it very interesting that all of this is still there's still redactions here on this stuff, these search warrants. And they're still sealed, apparently. Although, thanks to United States v. Comey, we know more about them. There's something here. There's just something here that is keeping this secret. And I don't think it's that if it was unveiled, everybody would know that Comey's a no good, very bad guy. I don't think it's that. There's no need for that. I think it's because there's a separate investigation. All right, the hard drive, the Columbia accounts, and the iCloud account that the warrant sought to seize information from. And by the way, so the question is, okay, let's say if you agree with me, or if let's play out the hypothesis that there's some other investigation, and that Richman's materials, there's something in there that is useful to some other investigation. Well, why then, you might ask, is Professor Richman trying to get these things back? Maybe he's trying to prove that the government lawfully has them by trying to get them back, and the government saying, actually, we need them, and going to a judge and saying, here's why. Because if he didn't, maybe the person that they're targeting would do that, and they're worried about them succeeding on a motion to suppress in a future case. So they're going to establish through these actions that the government lawfully has and maintains these materials and has a use for them. They're just coming at it from the other direction, using Professor Richman as the active force. As noted, the hard drive contained a forensic image by acting force. I mean, like, he's the one who initiates the action that's actually going to do the DOJ a favor here. All right, so forensic image of blah, 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 and they accounts with blah, blah, blah. And unsurprisingly, given Richman's occupation, his files also contained a significant quantum of privileged information involving multiple clients. Nice use of the word quantum. Every time you see the word quantum these days, almost 99% of the time, it's some bullshit artist using it. Of course, some people think that Professor Richman is a bullshit artist, so I kind of walked into that one. In recognition of this fact, in connection with the Columbia warrant, the iCloud account warrant, hard drive warrant number 2, but not in connection to hard drive warrant number 1, the government afforded Mr. Richman an opportunity to review the warrant returns. Why not for hard drive number 1? Professor Richman, through his counsel, availed himself of the opportunity, withholding privileged material, and produced privilege logs to the government. That process ended in 2020. The Arctic Haze investigation closed in 2021. In the summer of 2025, FBI and U.S. Attorney's Office for the EDVA initiated the new investigation of Comey. They looked at this stuff, and we already know all this because we just went through that case. We already know all of this. According to Judge Fitzpatrick's opinion, after the conclusion of the Arctic Haze investigation, Professor Richman's files, quote, set dormant with the FBI until the summer of 2025 when the Bureau chose to rummage through them again in connection with the investigation into Mr. Comey. Judge Fitzpatrick found on September 12, 2025, an FBI agent assigned to this investigation into Comey was instructed with the, quote, apparent concurrence of U.S. Attorney EDVA to review a full Celebrite extraction That's the program that goes into devices and gets everything on them, even stuff that you thought was deleted. And its password protected. It breaks it all. A full Cellebrite extraction and reader reports of Professor Richman's iPhone and iPad backups for communications between Professor Richman and his former client, Mr. Comey. Judge Fitzpatrick noted that although the 2025 investigation was focused on a different person, was exploring a fundamentally different legal theory, and was predicated on an entirely different set of criminal offenses, the government made the inexplicable and highly unusual decision not to obtain a warrant for this search. Footnote 9. Fitzpatrick noted that the government may have made this decision not to obtain a warrant in its haste to indict Mr. Comey before the statute of limitations expired. He further noted if a new warrant had been sought by the government and issued by the court, the Fourth Amendment would have required it to be narrowly tailored, authorizing access to only materials within a limited time frame and relevant to the new offenses under investigation. In addition, any new warrant would have imposed strict procedural safeguards to ensure privileged information was not reviewed by the prosecution team. As a result, the parameters of the 2025 search warrant would inevitably have had a different and much narrower scope than the warrants, like a new one would have. Faced with this prospect, the government chose to unilaterally search materials that, 1, were seized 5 years earlier, 2, seized in a separate and since closed investigation, and 3, that were never reviewed to determine whether they seized information responsive to the original warrants, 4, that were likely improperly held by the government for a prolonged period of time, 5, that included potentially privileged communications, 6, did so without ever engaging the privilege holders, and 7, did so without seeking any new judicial authority. According to Judge Fitzpatrick, the materials seized from the warrants were the cornerstone of the government's grand jury presentation in the Comey case, and they were not properly obtained. They weren't reviewed. It was not right. It was not done correctly. With respect to the government's over-seizure and consequent violation of the warrants, Judge Fitzpatrick concluded that the facts establish a reasonable basis to challenge whether the warrants were executed in a manner consistent with the Fourth Amendment and other orders of the issuing court, and the facts establish a reasonable basis to challenge whether the government exceeded the scope of the warrants in 2019 and 2020 by seizing and preserving information that was beyond the scope of the warrants. That is, information that did not constitute evidence of violations of 18 U.S.C. 641 and 793. With respect to the warrantless search conducted in September 2025, Judge Fitzpatrick found that the facts establish a reasonable basis to challenge whether the government had the lawful authority to search Professor Richman's files anew in 2025. And the facts establish a reasonable basis to challenge whether the government's 2025 seizure of the files included information beyond the scope of the original warrants. Judge Fitzpatrick concluded that the government's misconduct was so egregious that the nature and circumstances surrounding the government's potential violations of the Fourth Amendment and court orders establish a reasonable basis to question whether the government's conduct was willful or in reckless disregard of the law. I think what we're going to find out, I think DOJ is going to end up getting a new search warrant for these things. But not because they're going after Comey. All right, we don't need any of this. All right. So Professor Richman is arguing that all of this put together means that he was aggrieved by an unlawful search, an unlawful seizure, and by deprivation of property. This stuff belongs to him. They've had it too long. Give it back. The government violated Professor's Fourth Amendment rights in at least three ways. First, it apparently exceeded the scope of the warrants, seizing both responsive and non-responsive materials, leaving the government unchecked to rummage through all of the information seized from Richman anytime they chose for years after the warrants were issued. Second, it retained all of Professor Richman's files without having even attempted to segregate the non-responsive from the responsive for more than 4 years, from 2021 to 2025, a years-long seizure that was patently unreasonable. Third, 4 years after the closure of the Arctic Haze investigation, it conducted a new warrantless search of that property. And in connection with an unrelated investigation to which the stuff was originally seized. I want to point something out here that is a distinction that may come up later in a DOJ filing. Remember, at the beginning of this, it acknowledged that some of this stuff was voluntarily given. Professor Richman agreed to allow the government to image his personal computer for the purpose of identifying and deleting certain sensitive documents, and subsequently agreed to a limited search of the image. So I wonder if DOJ is going to file they're going to file some information saying some of this stuff was seized from the search warrant, but other stuff is part of what Richman agreed voluntarily to allow the government to do, because he agreed to allow the government to image his computer. And there may be something, there may be a battle or a back and forth over what the government was actually allowed to delete and whether or not they deleted more than they should have, or they went beyond what they were supposed to in connection with the Comey memos. But I'm just wondering if that might come up and then be like, okay, yeah, we got more than what the search warrants were for that came up later in Arctic Haze. But before Arctic Haze, there was the Comey memo stuff. And Mr. Richman volunteered his computer to the FBI, and they took his whole computer and imaged it and then gave it back to him. The computer, minus the Comey memos being on it, and they kept the image. So I'm just wondering about that. Seems like something that could develop. Okay. Just read that. Okay. The government violated Professor Richman's Fourth Amendment rights when they exceeded it. I think we got the gist of this. Okay. Another redacted section, which has to do with one of the warrants. Very interesting. What is this right here? Okay, we know all this. I don't really need to read it. He's just making his argument about what they improperly retained it. And let's see. Even though Arctic Haze concluded in 2021, the government to this day indefensibly retains Professor Richman's files. And I think DOJ is going to come in and say, actually, we have a very good reason to retain them. Okay, so what he asked for. I think they're going to come in right here. They're going to say, we have a basis to retain them, and here's why. You go back. They're going on and on. On and on. But they're kind of saying the same thing over and over. All right, the court should grant Mr. Richman's relief the immediate return of his seized data and hard drive, and the deletion of any copies in the government's possession. While the court need not reach other factors, blah, 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 an initial matter, the government's retention of the files poses significant privacy issues. They got all this stuff, plus the attorney-client privilege stuff that they have, financial files, and they go on and on about student files and private emails, and they seized all these things that had nothing to do with what the government was looking for at the time. Okay, so you get the point. And by the way, I said earlier about how I think this is an action that it's going to get the DOJ to argue and a judge to decide that no, actually the DOJ does have a use for this stuff and it is lawfully retained and maintained by DOJ. These materials are. How would that benefit DOJ? I think it would benefit them because, let's say in a grand conspiracy case that might loop in some evidence that they obtained from Richman, a defendant might say, hey, that evidence they got from Richmond is old, the search warrants are expired, the original case was closed, and then they shouldn't even be using that against me. And that judge will have to look at this, and the DOJ will come and say, hey, a judge already looked at this and already decided that the government has and maintains this material lawfully, which cuts off that argument. And something like, how do I say this? Like if you're strategizing this grand case, a grand conspiracy case against some very bad people who hijacked our government, in our intelligence and law enforcement services in a lot of ways, in order to stop Trump, quote unquote, or whatever, or at least hinder his administration, and to protect Hillary and some other very bad, swampy people, you need to strategize how to block off all of their exits from being held accountable. And this would be one way. It may seem small, and it may end up being small, and I may end up being wrong. But there's way too many things wrong with United States v. Comey for it to have been about getting Comey. It makes so much more sense that it's about getting materials, not getting Comey. And even some of the clickbaity, outrage bait accounts and influencers who at the beginning of United States v. Comey were posting all over their social media about how this is it, Comey's caught, there's no hope for him, they have the evidence, he's busted, he's going to be in jail, like all the stuff they were just hyping it up about how they got Comey dead to rights. 2 weeks after it's been dismissed, they're like, it was never about getting Comey, it was about getting other stuff, and everybody knew that. Like, whatever, dude. Whatever. Okay, so anyway, the judge comes in and the judge puts an order in saying that, all right, it's provisionally sealed, this stuff right here, which maybe it will be unsealed at some point. It's provisionally sealed. I just now caught that. I like that. And the government needs to respond. Certificate of service to the government. Then we got some front of the court filings, blah, blah, blah. And then where's the next one? And then Richman does a motion for a temporary restraining order, stopping the government from using any of this material. And which, of course, was granted. And then that's what a lot of news reporting has been about, how the government got there. And they don't even say that it's not the government doing it, it's Daniel Richman doing it. But they said this judge is protecting Comey by sealing off this evidence so that nobody can ever use it. Well, it's temporary. It's a temporary order, and it only lasts until, I want to say it was December 9th. The judge ordered, which is a different judge from in the Comey case. This is Colleen Cotelli. It's someone with two last names, Collar Cotelli. I totally dyslexic her name. I applied dyslexia. I don't have dyslexia, but I definitely dyslexia'd her name just now. Okay, so she ordered the government to identify, segregate, and secure the image of Richman's personal computer that was made in 2017, his email accounts, his iCloud account, and any copies of those files or materials extracted or derived from those files, which might be one of the things that this is all about. Because all that stuff, that wasn't done before. That's how that FBI agent got exposed to attorney-client privilege materials, is because it wasn't properly segregated. So she orders them to do that. And then she orders that they can't access those materials after they've identified and segregated it and secured it. They can't access it. They can't share it. They can't disseminate it. They can't disclose it. And then they have to certify to the judge by December 8th that they've done this. And they have to... Temporary restraining order is in effect until December 12th. Friday, December 12th, and then finally it's ordered that no later than Tuesday, the government shall file a response, okay? Get some notices of people filing in here, and then a motion for return of property. This is the motion in opposition, okay? So this is where, let's see. First, the government came in and said, we want you to temporarily dissolve this restraining order. That was the first thing the government did. So that motion is 20 pages. Then the other filing, is this the same thing? It's also 20 pages. Maybe I opened it up twice. Let me check real quick. I'm going to make a video on both, but this motion to dissolve is here. Memorandum in opposition here. They're the same thing. Are they the exact same thing? Let me go down to here and go down to here. Yeah. It looks like the government came in and filed both. They labeled it motion to dissolve and then memorandum in opposition. But they're both the same thing. One's document 12, one's document 13. Either way, I'm going to make it its own. I'm going to make it its own video. So I'll end this video here. This is kind of like the intro to the case. And then I'm going to immediately record a video going over the opposition. All right. See you in the next one. All right. Continuing, taking a look at Richman v. United States. I did check, and document 12 and 13 are the exact same. One says motion for order to dissolve temporary restraining order, and the other one says memorandum in opposition to motion 1, which is Richman's original motion that brought the whole case about. I don't know why they did this. I don't know. But I don't know. I understand, like, I'll see it sometimes where they'll make a motion, but then they'll also have a proposed order, as this one does. There's a proposed order down here. So maybe these were supposed to be separated. Seems so. But either way, this is the government's opposition, and I'm very interested in it because this may tell us quite a bit about what the government wants to do with the materials they have from Richman. So they're saying neither request from Richman is legally appropriate. The Richman's motion for a return of property is actually a collateral motion to suppress, aimed at hindering the government from using that property as evidence in a separate criminal proceeding in another district. I'm sure they mean the one against Comey. And his request for preliminary relief, the restraining order, is in effect a request that the court enjoin the government from conducting an ongoing criminal investigation and potential prosecution. Enjoin in this instance means stop. Richman's Rule 41G motion is not designed to secure the return of property that he needs or wants. It is a strategic tool to obstruct the investigation and potential prosecution of James Comey, and granting it would have the effect of serving a suppression motion or suppression ruling if Comey is indicted again. But that is emphatically not the purpose of a proper Rule 41G motion. Similarly, the court's grant of Richman's request for preliminary relief, which would be the restraining order, has effectively enjoined the government from investigating and potentially prosecuting Comey. But federal courts cannot enjoin federal criminal prosecutions. A civil plaintiff cannot circumvent bedrock federal criminal procedure via an equitable proceeding like this one. So the court should dissolve its temporary restraining order and deny petitioner's motion. I just had a thought. It's probably harebrained. It's probably, if I knew what I was talking about, I probably wouldn't have this thought. But I'm having it, so I'm going to share it with you. DOJ has quite a bit of evidence that they gathered from the mid-year exam investigation, which is the investigation into Hillary Clinton's server. They still have the Wiener laptop. They have the images of Hillary's server. They have images of the DNC hard drives from when the hack happened. They have a number of things. I don't know what they have from Uranium One or Clinton Foundation investigation, but they have stuff. Is Richman doing this in order to get a ruling that firms up in a contemporary court in D.C., a relevant court, and then a contemporary ruling, meaning one that's recent, to where a civil plaintiff can't stop a criminal prosecution from going forward or an investigation going forward because of their request for their property back? Such as we might see someone like Hillary or Anthony Weiner or Huma or whoever try and pull something like this to try and block or hinder an investigation that's reopened into some of that stuff that was seized during mid-year exam, Clinton Foundation, other things like that. Just a thought. All right, so they want, obviously, like I said, they want the court to dissolve the restraining order and then deny Richman's motion for his stuff back. So they want to keep it. DOJ wants to keep this stuff, and they're saying it's because they want to go after Comey, which I don't think they can do. All right, Arctic Haze investigation. Let's see what they say about Arctic Haze. Let's see. Richman served as special government employee from June 2015 to February 2017, which means he wasn't an FBI employee when the supposed leaks happened, which is another fatal flaw in the original indictment here. One of many. Shortly after his departure from FBI, the government began investigating whether Richman had disclosed classified information to the New York Times concerning Comey's decision-making process concerning the FBI's investigation into former Secretary of State Hillary Clinton's use of a private email server. The investigation demonstrated, among other things, that Comey had used Richman to provide information to media concerning his, that is, Comey's, decision-making process concerning the Clinton email investigation, and that Richman had served as an anonymous source in doing so. During the course of the investigation, also as a non-anonymous source, as a named source. During the course of the investigation, the government sought and obtained 4 search warrants and seized evidence for violations of 18 U.S.C. 641 and 793 from Richman's email accounts, hard drive, and forensic image of his computer and his iCloud account. Comey provided relevant testimony to the Senate Judiciary Committee shortly before his employment as FBI director was terminated, and again on September 2020. In May 2017, he testified in response to questioning from Senator Grassley that he had never authorized someone at the FBI to serve as an anonymous source regarding the Clinton email investigation. And in September 2020, he reaffirmed that testimony in response to questioning from Senator Cruz. And at the time that article came out, they were investigating, Richman was not a government employee. In September 2025, because they leave that bit out. In September 2025, a federal grand jury in the Eastern District of VA indicted Comey. After the indictment was returned, government filed a motion seeking judicial assistance in implementing a filter protocol. During subsequent litigation related to that request, as well as a motion filed by Comey seeking access to grand jury materials, The assigned magistrate judge raised concerns regarding both potential Fourth Amendment issues and Comey's attorney-client privilege vis-a-vis Richman, who began to represent Comey shortly after his termination as FBI director. A lot of this is retread. The indictment, I mean, so far this is all retread. We're all familiar. If you were with me as I followed United States v. Comey, then this is all refreshing. We already know this. Shortly after the indictment was dismissed, Richman filed his motion here. Approximately a week later, Richman sought a temporary restraining order. The next day, without awaiting a response from the government, the court issued an ex parte temporary restraining order. They granted in part and deferred in part Richman's request for relief. The court ordered the government to identify, segregate, and secure the image of Richman's personal computer that was made in 2017, his Columbia University email accounts, and his iCloud account, as well as any copies of those files and any materials obtained, extracted, or derived from those files. The court further ordered the government not to access the relevant materials after they were identified, segregated, secured, or to share, disseminate, or disclose the covered materials to any person, without first seeking and obtaining leave of the court. I'm going to skip this part. Petitioner's motion is a collateral and premature motion to suppress evidence. Remember, I said that in the last rule. I said that. And another criminal proceeding masquerading as a motion for return of property. It is impermissible for a court to enjoin a criminal investigation and potential prosecution in another district by restraining use of evidence to benefit a third party. Okay. I'm not really worried about this 41G argument, whether it is or is not. Not really worried about that. But I want to see if there's any... What is this? Nope. Okay. Here is explained below. It is plain that Richman, via his 41G motion, in fact seeks a similar remedy. He's requesting that the court issue an order directing the government to immediately return or delete certain materials illegally seized and or retained by the government, as well as any copies thereof. In sum, the question is whether the motion seeks not just the just equitable return of property, but also the suppression of evidence, i.e., to prevent the government from using the evidence in criminal proceedings, which might be something that Hillary, McCabe, others would be very worried about. Richman's misguided use of Rule 41G. By the way, let me just pause here. Do you find it believable that Daniel Richman, a Columbia Law University professor, a former Manhattan prosecutor who prosecuted the mob, for a time a special government employee, Comey's counsel, do you find it believable that he would not know what a Rule 41G motion is and how to use it? That's not really believable, is it? It seems much more likely he knows exactly what he's doing, right? Just like I know exactly what I'm doing when I sit down to record and I don't turn on the lava lamp. I planned that the whole time. And does it really seem believable that he really needs all of this property back? And does it seem believable that the government would fight to maintain this property and keep it if they didn't have a use for it? Just things to think about. Rule 41G is not intended to deny the United States the use of evidence permitted by the Fourth Amendment and federal statutes, even if the evidence might have been unlawfully seized. That's so because the return of seized property under Rule 41G and the exclusionary rule serve fundamentally different purposes. Suppression helps ensure that law enforcement personnel adhere to constitutional norms by denying them and the government they serve the benefit of property it unlawfully seized. Rule 41G is concerned with those whose property or privacy interests are impaired by the seizure. Suppression applies only to criminal defendants, whereas the class of those aggrieved can be much broader. Consequently, Rule 41G avoids an all or nothing approach, whereby the government must either return records or make no copies or keep originals, notwithstanding the hardship to their owner. Indeed, the rule contemplates that even when a property owner has a valid claim for the return, the government will often be entitled to preserve a copy for future use if the materials are relevant to ongoing or contemplated investigations and prosecutions. Once again, the purpose of Rule 41G motion is not to preclude the use of evidence in a criminal trial, just the opposite. If the purpose of a motion is to suppress the use of evidence, it is not a proper motion under 41G. Not at all, but instead an indicator that the matter should be adjudicated through a motion to suppress under the Fourth Amendment and the exclusionary rule. Accordingly, as the D.C. Circuit has explained, even in the face of a Rule 41G motion, the government can reasonably retain the evidence in an ongoing criminal investigation or trial. That is, it may use seized effects for legitimate law enforcement purposes. And that's what they're going to assert, isn't it? Underscoring the same theme, a civil plaintiff may not typically use a civil action as a vehicle to attack a criminal prosecution. That's Manafort v. Department of Justice, 2018. The Court of Appeals has applied this reasoning to hold that in light of traditional equitable principles and concerns about finality, the subject of a criminal investigation may not bring a civil action to attack or impede or attack an impending federal prosecution. Okay. Under these principles, the court should not permit Richman to collaterally seek the suppression of evidence in the Comey prosecution via Rule 41G. It is clear that Richman's 41G motion is not a valid or meritorious motion for a return of property, but instead a transparent effort to suppress evidence in the Comey matter that is improper multiple times over. And so the court should deny the motion and dissolve the temporary restraining order that it issued on an ex parte basis last week. Richman does not genuinely want any property back. After all, the government merely has copies of his data. Yet he sought an order directing the government to immediately return or delete certain materials legally seized or retained by the government, as well as any copies thereof. Moreover, he sought and obtained an order temporarily enjoining the government from accessing, searching, relying on, or reviewing the relevant materials, as well as a permanent injunction prohibiting the government from making any further use of the improperly seized and retained materials. His request for copies of the seized documents and an order directing the government to cease inspecting the evidence pending a ruling confirms that his motion seeks suppression of evidence, not the return of property. That makes a lot of sense. Richman, therefore, does not seek just the equitable return of property, but to prevent the government from using the evidence in a criminal proceeding. They're making a lot of sense. Okay, and then here, let's see. The close connection to the Comey prosecution is also demonstrated by the timing of Richman's motion. Richman does not remotely explain why he did not seek relief via Rule 41G after the Arctic Haze investigation closed in 2021 without any charges being filed. But the timing makes perfect sense once one realizes... Oh, I lost my place. The timing makes perfect sense once one recognizes that this motion is in substance a suppression motion directed at the Comey prosecution if Comey is reindicted. Sorry, something caught my eye, and also I have about 3 or 4 thoughts running in my head. And Richman is flatly mistaken that any charges related to the underlying conduct are time barred simply because the district court held that the prior indictment was void as a result of an appointment defect. The statute of limitations has indeed expired on the charges with which the grand jury indicted Comey, but 18 U.S.C. 3288 expressly allows the United States to reindict whenever an indictment charging a felony is dismissed for any reason. after the period prescribed by the statute of limitations. All right, I'm going to grab this because this is why I keep on saying you should not expect Comey to be reindicted, at least not successfully. But this is also why people seize on the dismiss without prejudice and think that 18 U.S.C. 3288 is going to allow for him to be reindicted. When you go and look at this, I believe there is part of it that says the indictment that actually occurred has to have been valid. Like, it can be dismissed for some reason, any reason. But if the indictment itself that was dismissed was an invalid indictment, then it doesn't preserve the statute of limitations. Okay. Whenever an indictment or this is what it actually says. Whenever an indictment or information charging a felony is dismissed for any reason after the period prescribed by the applicable statute of limitations. So someone's indicted before the SOL runs out, but then after the SOL has run out, at some point the indictment is dismissed. A new indictment may be returned in the appropriate jurisdiction within 6 calendar months of the date of the dismissal of the indictment or information, or in the event of an appeal, within 60 days of the date the dismissal of the indictment or information becomes final, or if no regular grand jury is in session or the appropriate jurisdiction when the indictment or information is dismissed, 6 calendar months. They have to have, that's what it means. There's an indictment against someone before the SOL runs out. But while they're under indictment, the SOL runs out. And for some reason, the indictment's dismissed without prejudice. DOJ has 6 calendar months from that point to refile an indictment. 6-month grace period to reindict, even though the statute of limitations is run out. That's what everybody is saying is DOJ's. Did it come back? There, it came back. I may need to buy a new cord for Christmas. That was weird. Okay. That's like the third time it's come loose on me today while I've been recording. Okay, so they have a 6-month grace period to refile, and that's what everybody is seizing on. But they're leaving out, this section does not permit the filing of a new indictment or information in charging someone where the reason for the dismissal was the failure to file the indictment or information within the period prescribed by the applicable statute of limitations or some other reason that would bar a new prosecution. And if you look at Judge McGowan-Curry's ruling, her ruling dismissing Comey's case without prejudice, she brings up 18 U.S.C. 3288 here, and she quotes it just as we just read it. But she says right here, let me see, where did she put the, it's earlier, too late. Okay. Right here, this footnote. Generally, the return of an indictment tolls the statute of limitations on the charges contained in the indictment. That's United States v. Ojadokin. I don't know how to say that name. That's from 2021, upheld by the Fourth Circuit. An invalid indictment, however, this is the key part. An invalid indictment cannot serve to block the door of limitations as it swings closed. That's United States v. Chrysopt Corp., District of Maryland, 1991. And then it was also upheld in United States v. Gillespie in 1987, where they said a valid indictment insulates from the statute of limitation problems any refiling of the same charges during the pendency of that valid indictment. But if the earlier indictment is void, there is no legitimate peg on which to hang a judicial limitations tolling result. Okay, so she, in her ruling here, she is advising, hey, the Attorney General came in. This is what she was talking about where she put this footnote. She's saying the Attorney General, A.G. Bondi, came in on October 31st and said, hey, I reviewed this case. I reviewed the indictment. I reviewed the grand jury materials. Lindsay Halligan did right. The indictment is valid. I'm authorizing her to prosecute Comey. I'm ratifying the indictment against Comey. A.G. Bondi made this, remember that order? How she came in and just backed up her girl and backed up her girl's work, right? And that's what this judge, this senior district judge out of South Carolina, McGowan Curry, is talking about here, and says Bondi coming in on October 31st, she came in too late. It was past the statute of limitations. And the government responded the Attorney General's ratification was proper, that it was legally proper, because it's within the grace period. So even if the first one against Comey, the only one against Comey was invalid. So let's say that what the government was arguing is that should you rule, this is what the government argued in their motion to try and protect the United States v. Comey. Should you rule that Halligan is unlawfully appointed, you can't dismiss the case, because it's as if A.G. Bondi obtained a new indictment on October 31st, because that came within the grace period that 18 U.S.C. 3288 allows, which is this right here. And that's what everybody's talking about as why the Comey case can be refiled, is because of this statute. But in her ruling, she says, look, it doesn't fly. It doesn't fly because in the case of United States v. Ojedukin or Dokin, whatever, from 2021, and in United States v. Chrysop Corp. Of 1991, and United States v. Gillespie in 1987, the courts held that an invalid indictment does not preserve that grace period. It's as if there was no indictment. If the earlier indictment is void, there is no legitimate peg on which to hang such a judicial limitations tolling result. In other words, there's nothing to peg onto for that grace period, that 6-month grace period, to come in. It's as if there was no indictment. In other words, 18 U.S.C. 3288 doesn't apply. It doesn't apply. And that's why I keep on saying, don't expect a new United States v. Comey case to be filed, or at least not successfully, because Comey and his team are going to go directly to this. They're going to bring up this case, and they're going to bring up this case, and they're going to bring up this case. And I don't know any other cases they might bring up, but if there are those, they'll bring them up too. But look, you have from 1987, you've got 40 years. You've got 40 years of this being the case. You can go back in case law 40 years. You can go back in case law 4 years. Same thing. An invalid indictment does not preserve that 6-month grace period that 18 U.S.C. 3288 provides. I hope that's super clear to everybody. And here again, DOJ is bringing it up, saying, hey, we've got 6 months to bring an indictment. And anytime there's whether it's dismissed for any reason, that's what they're going to argue. Okay. They're going to come in and say, yeah, but 18 USC says if it's dismissed for any reason. And that's going to be the contentious point. That's what they're going to hang their hat on. And Comey's team's going to hang their hat on those other cases. We'll see who prevails. But I hope that makes sense. All right. I got to check on dinner in the oven. That's one of the thoughts that I was distracted by earlier. I got to check on dinner. I'll be right back to finish the recording. Okay, back. Dinner's ready. So I'm going to wrap this up. Okay. Given that Richman has all but conceded that he seeks a suppression remedy directed at a future prosecution, if Comey is reindicted, it would be unreasonable for the court to allow Richman to collaterally secure that result. It says, pending terminated trial, that's room that Richman cannot seek. To be clear, the government denies that there's been any violation of Fourth Amendment, but reserves the right to fully litigate this issue in the context of a proper suppression motion in a criminal case, rather than here in this motion for his property back. Of particular note, while Richman contends that the government erred by using evidence properly searched for and seized in an investigation of potential violations of 18 U.S.C. 641 and 793, in ultimately determining to seek an indictment charging Comey with 18 U.S.C. 1001 and 1505, Richman is legally mistaken. There is, quote, no reason why property seized under a valid search warrant, then thus lawfully obtained by the government, may not be used in the prosecution for a crime other than that which may have been described in the affidavit. Moreover, even if there were a Fourth Amendment violation, it's clear under governing law that even the presentation of such evidence to a grand jury wouldn't be a sufficient basis to dismiss an indictment. Right, but the violation of the Sixth Amendment is actually more so the problem. Finally, it would be unreasonable for the court to grant Richman the relief he asked for. Okay, for all these reasons, the court should deny the motion. And the temporary restraining order should be dissolved for substantially the same reasons. Okay, so that was theirs. And then what happened next, which I'll go ahead and get to, is that the judge set deadlines for each side to respond. Let's see. I wonder if he mentions how docket entry 12 and 13 are identical. Before resolving the petitioner's motion, which would be Richman, this court will receive evidence of any factual issue necessary to decide the motion. If the government contends that it needs access to the materials at issue to present evidence that is necessary to the resolution of Richman's motion, the court will entertain a request for leave to access the covered materials. However, the court is mindful that petitioner Richman contends that some of the materials at issue are subject to attorney-client privilege, and some are unresponsive to the warrants under which they were seized. Presumably, in part due to these issues, the government acknowledges that it sought judicial assistance in implementing a filter protocol. Although no one has yet formally entered an appearance for the government in this matter, that's strange. The court understands that the government will be represented here by at least one of the same attorneys who appeared for the government in the Comey matter. It therefore appears to this court that a filter protocol may also be warranted in this case. Interesting. Accordingly, no later than 12 p.m. tomorrow, December 10th, the government may file a brief motion for leave to access the covered materials for the limited purpose of responding to Richman's claims in this case. Petitioner Richman may file a brief response to the government's motion no later than 5 p.m. tomorrow. Okay. And then what happened? What happened? Some errors happened. Notice of error, notice of error, notice of error, notice of error. Okay. Invalid signature on document must match PACER login. That's okay. And then this order setting deadlines for filing notices. Is this the same thing again? To date, the government's certification of compliance with the court's order has not been filed in the docket. And attorneys Blanche, Halligan, and McBride have not yet fully entered their appearances. So he gives them another day, December 11th. Something went on with this. Attorney Bailey is therefore listed on the docket. On December 9th, Attorney John Bailey filed the government's number 12 response, docket entry 12, which we read, because it's identical to 13. Attorney Bailey is therefore listed on the docket as appearing on behalf of the government. But however, Bailey's electronic signature does not appear in the body of the government's response. Only the electronic signatures of attorneys Blanche, Halligan, and McBride appear. And Attorney Bailey has not filed a notice of appearance. Oh my gosh. To ensure the counsel who are accountable to the government representations and legal positions in this matter are accurately identified in the official record. Everybody's got to file proper appearances by tomorrow. Damn it. Oh gosh. Man, what is it about? I don't. I'm gonna keep it to myself. I'm keeping myself. Okay, December 12th. So did they file an appearance? Compliance. There's the notice of compliance filed by Halligan, saying we complied with your order and we segregated things. Okay. And then on December 12th, what happened here? Or did I already have that open? Where's it opening at? There it is. There's the tab. For reasons stated in the accompanying memorandum, it is hereby ordered that petitioner Daniel Richman's motion for return of property is granted as to the image of his personal computer. And he filed everything. They granted everything. The judge did. Order that United States may prepare one complete copy of the cover materials and deposit that copy under seal in the U.S. District Court of the Eastern District of Virginia for future access pursuant to a lawful search warrant and judicial order. Okay. So it's granted, or return of property motion is granted. But further, the United States is ordered to prepare a complete copy of all those materials and deposit that copy under seal in the EDVA for future access pursuant to a lawful search warrant and judicial order. And it is also ordered that the government shall return to petitioner Richman all copies of the cover materials, except for the single copy that the court has allowed to be deposited under seal in the EDVA. Next, it's ordered that the Attorney General of the United States shall certify to this court, no later than 4 p.m. on Monday, December 15th, that the United States has taken each of those steps required. And it's also ordered that all provisions of this court's order on docket entry 10 are extended until the government certifies its compliance. And docket entry number 10 was the temporary restraining order, I believe. It is right there. Yes, temporary restraining order. Okay. And lastly, it's ordered that the remaining requests for relief in petitioner Richman's motion for a temporary restraining order and the government's motion to dissolve the temporary restraining order are denied as moot. This is final appealable order. Signed, Colleen Collar-Cotelli. Okay. That was quick. Maybe she got tired of the errors and was like, no, we're gonna do this. Return it all, but make a copy of it first and file it under seal in the EDVA for future use or future search warrant use. Okay. Interesting. And okay. There's her memo explaining it. I may look at that in a minute, but now I'm really intrigued as to what happened next because the case hasn't stopped. Emergency motion to clarify. The United States comes in and files a motion to clarify. And then we get appearances from Halligan and appearances from McBride. Like days later, 3 days later, they're filing appearances in the case. Okay, that's going to be my next video, is going over these emergency motions to clarify, because there's several things happening. This has not stopped. This just got more intriguing than I expected. Okay, if you like this video, my link tree is in the usual spots, description and in my profile. There you can find all the places to follow me, all the places to watch, listen, and all the ways to support. You need a last-minute Christmas gift, Benson Honey Farm, bootleg products, they're delicious. Manly Cans is a great place to get a gift for the manly man in your life. I've gotten some items from them, and all of them are great. And if you just want to buy me a cup of coffee and keep me caffeinated for this kind of work, Ko-fi.com. If you want to join all the folks that are core supporters of mine and really keep this show going and all the research that I do, justhuman.substack.com, $7 a month. You're buying me 1 cup of coffee a month and you're throwing $2 into the Pacer account. So thank you very much. I will see you on the next video. All right, guys, one last thing for this episode, and it doesn't have to do with Richman. It's this news right here that Dan Bongino is going to be leaving the FBI in January. Now, he hasn't said where he wants to go, but he says, I will be leaving my position with the FBI in January. I want to thank President Trump, AG Bondi, and Director Patel for the opportunity to serve with purpose. Most importantly, I want to thank you, my fellow Americans, for the privilege to serve you. God bless America and all those who defend her. And I want to say that before Dan was at the FBI, I would not describe myself as the biggest Dan Bongino fan, but not someone who didn't like him. It's not that I disliked him, but I saw him as being I listened to his show kind of steady for a while when he was pretty early on. And I liked him just fine. And I would occasionally listen to his show here and there. But I would mostly consume his show through clips over the past, like, probably 3 years or so. I was probably maybe 2+. I would really only consume his show through, like, the clips I saw going around. And I liked Dan just fine, but I did see him as part of, like, the reactionary right-wing conservative MAGA media sphere. And that's just not my flavor. I didn't think that Dan was wrong or bad or anything like that. Like I said, I didn't dislike him, but it just wasn't my flavor of media to consume. And I really thought he was more of, like, just like, definitely not clickbait or outrage bait like others, but a little bit more so on the grr Democrats bad, and just kind of leaning that way, I guess. So anyway, those of you who've been listening to me for a long time, you're not surprised that Dan his show isn't exactly my flavor. However, I did see a lot of clips from Dan, and I've played clips from Dan's show on my show because he's done a great job of getting material, and he has an investigative nose, and he was a law enforcement officer. So at the same time, there's a thing about Dan that I got and that was my flavor and I liked very much. So anyway, through Dan being deputy director of the FBI, I've become a fan of Dan, and I've become I've really gained a lot of respect and admiration for him. And I think that he has had a very positive effect on the FBI, 1, and 2, on people's perception of the FBI. At the same time, he has become a favorite target of exactly that type of media I was just describing, the outrage baiters, the clickbaiters, and the people who are just crude in that way and reactionary. And so in a way, it's like the type of media he used to engage in has come back around and has made him a target. And I think some of Dan's commentary that he's had since being FBI agent, he's gotten to more than once how he used to think this way, and now he's seen things from this side, and how he used to think and have these theories, conspiracy theories about J6, about the pipe bomber, about Epstein and Maxwell, and these other things. And then now that he's been on the inside and he's seen the evidence and he's committed to investigating that original evidence, he's like, oh, I see it differently now. And I think that's very much to his credit. And man, I respect him for being honest about that. There was a time recently where he was confronted by a reporter about how these are the things you used to say about this issue. I think it was the J6 pipe bomber. And now you say this. And he was like, yeah, I used to get paid to say things on the radio, and those are the things I thought. And then I got inside and I said, let me see the evidence. And I looked at it and I ran the investigation to get the guy, and now I understand. And I just respect the hell out of him for that. At the same time, there's also this other group who hates him for it. And so my hope for Dan, whatever he does next, Trump made a comment that Dan wants to go back to his show. And to be clear, Dan's a multimillionaire. He's made a lot of money off of his podcast. And in no way did he need this job or the grief that comes with it or the risk. But he took it anyway, and he served his country. And I think he's due so much gratitude from us. And I think that now that he has been inside the FBI and he's seen so many of these investigations that have had so many conspiracy theories swirling around them for so long, and accusations aimed at the FBI, at tearing the FBI apart. Now that he's been inside and he's can come out of it, I'm hoping he can be a voice of reason and of nuance, and can really help rehab the FBI's image and by extension DOJ's image in the minds of the right. I think he can do a lot of good, but I don't know that he's going to go back to his show. Trump only said that Dan wants to go back to his show in just a passing comment. He may want to. That doesn't mean that's what he's going to do next. It might be Dan's headed to somewhere else in the Trump administration. Hopefully it's not that he's leaving because of any sort of health concern. He's already won that battle once, and I really do pray that that is not the case. But I do want to extend my gratitude to Dan. I think he's been a very positive force on the FBI, and I have watched with I got to think about how I want to phrase this. One of the things that Dan has shown me, and it's not that he meant to, but one of the things I've observed is that so many of these very bad elements that have infiltrated MAGA and have infiltrated the right have really made Dan a favorite target of theirs. And I've watched them coordinate their attacks on him. And what it's done is it's made me respect him more, and it's made me see them for who they are even more. It's confirmed what I already suspected about them. I'm talking about the faux FBI whistleblowers and the people who advocate for civil war and disorder and a degradation of the things that bring law and order to our country. And I've watched Dan take that over and over again from those people. And I really hope that more and more in MAGA see it, but I don't think they do. I think it's the kind of thing that those of us who spend a whole lot of time on social media, probably too much, and who consume this content are just our daily news junkies, we're the ones who pick up on it. And it doesn't make us smarter or wiser or better than anybody, but it does heighten your awareness that there are some really bad actors out there. And you watch the way they manipulate their audiences. And I don't want Dan to come out and like name names and like take them all down or anything, but I just hope he can, if he does return to the mic one day, or whether he returns to like some TV, wherever he goes, that he can take from this experience and he can be like just this really positive force on the right that hushes those others. Just hit my boom. That that his presence can diminish the influence that these malicious actors have on the movement. Yeah, and I'm really glad that Dan was in the FBI. I think he's done some tremendously good work. So, yeah. All right, that's going to be the end of the show. And if you don't know some of what I'm talking about, then you're probably better off not knowing, because there's some really bad people. There's some really bad people that have been after Dan, and they're going to count this as a victory. That's going to suck to see, but they might be surprised by what Dan does next. So I think their time is short anyway. So I pray that it is, and I pray for Dan and his family. So thank you all. Hope you enjoyed the show, and I will see you on the next one. Remember, man, we're all just human. We're all just trying to figure these things out. And man, that's what Dan did. Dan went to the FBI with a spirit of trying to figure things out, didn't he? And he did. He helped figure in so many investigations. One of them, most recently, the J6 pipe bomber. And a whole bunch of those people are trying to manipulate their audiences into believing that the FBI got the wrong guy. But Dan went in there with the spirit of, let's figure this out. And they did. We need more people like Dan. So, God bless him. God bless y'all. Remember, we're all just human. We're all just trying to figure things out. I'll see you on the next episode.